Please.
Well, strictly speaking, it's not declaratory relief. Actually, what they seek, because declaratory relief is relief where you ask the court to declare your right. Here, they're not asking the court to declare a right. What they're asking the court is to find the conduct by the respondents was unlawful. That's really what they're asking the court to find. So they frame it as a declaratory, but in truth, it is an application for an order of unlawfulness. Now, that's paragraph 1, prayer 1. Prayer 6 of the notice of motion is to direct the President.
Has this prayer been settled or not in its entirety?
I beg your pardon, my lady?
Has this prayer been settled?
Yes, it has. So, but it has been settled. A commission has been established. My lady will see from in fact, the promulgation was attached to the papers. Judge Rampepe is the judge who is in charge of the commission. She has 2 assessors. So that's, and I don't know this, but I was informed by Mr. Chaskelson's junior on the train here this morning that on the 1st of this month there was a notice put out by Judge Rampepe in which she set out what the progress will be over the next month. I think she's just started work on it. So it's settled, there is a commission. The reason why we refer to 6, which is the prayer for a commission, is because you will see that what the applicants want the commission to do is to inquire into whether, why, and to what extent, and by whom efforts or attempts were made to influence or pressure members of the NPA and or the SAPS to stop investigating and or prosecuting TRC cases, and whether any members of the NPA or the SAPS improperly colluded, and so forth. In other words, what they're asking, so what they require the Commission to do is to make a finding of unlawful conduct. That's actually what they ask the Commission to do. So we say, looking just at the notice of motion, you will see that what they seek in paragraph 6 is for the Commission to make findings of unlawful conduct, and that is what they're asking the court to do in prayer 1 of the notice of motion.
Those inquiries would be factual.
Yes.
And then the legal consequences.
Well, then the recommendations. The inquiry before the court would also be factual, and then the court would be required to draw conclusions and make findings of fact and law. And that's what the court would be required to do. So, my lady, so much for the notice of motion, and we say that already tells you why a stay is appropriate. But then, my lady, if one goes to and here I want to ask we're going to refer, my lady, to the founding affidavit in the main application, and there the submissions we make are these, and we'll take my lady there in a moment. The first relates to the TRC Commissioner's call for a commission of inquiry, and the second relates to the call by the families and civil society for a commission of inquiry. And what we say is, if my lady, in summary, my lady goes there, we'll take her there in a moment, then what my lady will find is that the reason for the commission of inquiry is because the facts are as yet unknown. So let's take my lady to the founding affidavit, and we go to paragraph 495 of the founding affidavit.
415.
495.
Where do I find that?
That's it. I'll tell my lady in a moment. That is at, it starts with before that, it's case line 001-205.
Thank you. Yes.
So the first is what the commissioners did in their letter, which is at FA 74, and FA 74, my lady, is
74, 75.
74. So FA 74 is 001-887, and that is case line 001-887. So recall, my lady, that this is a 2021 call by former TRC commissioners for a commission of inquiry, and at 001-888, at the foot of the page, under the heading "The Need for a Commission of Inquiry," what the commissioners say is this: while some evidence has been uncovered in the Nkadi Meng and Rodriguez matters, the reasons behind the suppression of the cases are not known, and the sources of such interference remains opaque. It is not known if arrangements and agreements were struck with individuals and entities outside government. The full means by which the will of outsiders was imposed on the NPA and the SAPs is yet to be exposed. It is not known how institutions with firm constitutional and statutory obligations to uphold justice so easily abandon their legal duties in respect of the TRC cases. In a nutshell, the TRC commissioners say a commission is necessary because we don't know the facts. And whatever we know is so opaque that we need a proper inquiry. That's what they say. Now, what they then do, I refer my lady to the founding affidavit. In the founding affidavit, so what the commissioners did was they proposed terms of reference. And if our lady goes to 001-205, those are set out in the founding affidavit, paragraph 495. And what the applicant says is the commissioners attached to the letter, which I read out to my lady, draft terms of reference for the proposed commission. The proposed terms included the following suggested issues to be probed. And then they set out what, in fact, my lady will find out broadly is in the terms of reference of the Commission of Inquiry. But they ask whether and to what extent and by whom efforts or attempts were made through any form of persuasion or inducement for any purpose, advantage or gain of whatever nature to influence or pressure members of the NPA and or the SAPs to refrain or stop investigating and or prosecuting apartheid-era cases referred by the TRC to the NPA or to abandon or undermine such cases. And then identify the role played in the alleged interference by any person within or outside government, including any current or former members of the National Executive, office bearers, and so it goes on. And the point about these terms of reference, my lady, is what they do is they display that what the commissioners were and are concerned about is that our society, through a commission of inquiry, will get to the bottom, to the truth of why it is that the TRC cases were not prosecuted and were investigated and were not moved along and so on. So that's that's primarily what they're concerned with. That, my lady, so that reason for the inquiry is echoed by the families, and at founding affidavit paragraph 510, and this is at case lines 001-211. They say, this is in their affidavit in the main application, in respect of the dire need for a commission of inquiry, we pointed out that there is no longer any dispute that the political interference happened, given that the NPA had admitted that it succumbed to interference and that in Rodriguez, both the High Court and the SCA had expressed their dismay at how such interference could take place in the new constitutional order. We'll get to Rodriguez, High Court and SCA, we'll get to that in a moment, but let's just deal with this. They then say the applicants. We noted that, and then they repeat what the commissioners say, which I've just read out to my lady at paragraph 4, is it 95 or whatever it is. So while some evidence has been uncovered in the Nkadimeng and Rodriguez matters, the reasons behind the suppression are not known. My lady will recall that Nkadimeng was primarily concerned with, I think one was the prosecution, the policy, and two was an application to direct the NPA to prosecute. And Rodriguez was concerned with an application by Rodriguez, who wanted the court to permanently stay his prosecution because of delay. That's what those were concerned with. So they were not concerned with what the Commission of Inquiry, what the commissioners and the applicants say the Commission of Inquiry will primarily be concerned with. The Commission will be concerned with the true facts behind why these cases didn't proceed, and that's what the Commission is concerned with. So that's what they say. That's the reason, my lady, they give for why the Commission is necessary. Then when we go to what they say about, in the founding affidavit, about unlawfulness. So remember, my lady,
in respect of the relief in...
Yes, correct. So what they do is they say, in the founding affidavit, they ask the court to direct the President to establish a commission of inquiry. They say the need for a commission is in order to get to the bottom of the reasons why those prosecutions didn't...
Who they were and so forth.
Correct. Then they come to unlawfulness. And about unlawfulness, this is now, unlawfulness relates to paragraph 1 of the notice of motion, pre 1 of the notice of motion. And here what they say is this. They say...
Paragraph?
At 001-217, paragraph 529. But it starts, is my lady there?
Yes, I am.
So the heading is a huge heading in bold capitals, violations of the law. So we read that to support the prayer 1. That's how we read this. And then at 529, the applicants say, those who imposed their will on the NPA and the SAPs to stop or undermine the TRC cases from proceeding, as well as those within those organizations who acquiesced to those demands, violated multiple constitutional and statutory provision. Now note, my lady, there's no identification of any persons here. It's simply, there are people who did this, and they who did that are guilty of these violations. Then they go on, my lady, to say, at paragraph 530, every constitution, this is the 001-219.
I do everything.
Every constitutional and statutory duty and obligation mentioned above was violated by those who imposed their will on the NPA, as well as the NPA leadership and its senior staff members involved in the abandoning of the TRC cases. Although the NPA enjoyed exclusive authority to institute criminal proceedings on its own version, it allowed others to impose their will on the authority to stop prosecutions that otherwise would have been pursued. And again, there's no identification of who these people are when they make their submissions in support of prayer 1. So 531, 001 dash, what's it, 220, I think it is. 531, in allowing others to effectively take their decisions, the responsible members of the NPA failed to act impartially, and so forth. And 532, the NPA and its responsible officials permitted other organs of state, alternatively members or employees of organs of state, and or other persons to improperly interfere or obstruct their authority. This, my lady, is precisely the opacity that the Commission said there was, despite what happened in Nkadimeng and Rodriguez. This is the opacity it complains of, and this is why it says we need a Commission to get to the bottom of the true facts, because things are so opaque, we don't know what the true facts are. I mean, I could stop there, as I did say to my learned friends Junior this morning. I'm going to be very short. I could stop there and say to my lady, well, that's precisely why
Well, let's just
we say that...
examine the legal principle.
Yes.
The applicants are dominus litis.
Yeah.
If the applicants want to proceed with their case in this court, notwithstanding the commission of inquiry, but if I understand the applicants in this matter's submissions correctly, I should not allow that because there aren't any facts that they could rely on. Well, isn't it then that the applicants will really not succeed?
No, but my lady, so remember, my lady, the court is, so we refer to the, at 010-7, we refer to, if it's a postponement, well, then it's the interest of justice. And if my lady orders a stay, so there's no real difference, they both require the interest of justice, but then what is relevant to a stay is that real and substantial justice must be done. Now, a court can't close its eyes to, it wouldn't be doing real and substantial justice to what is obviously, what has been an intractable problem over many decades, the prosecution of TRC cases, which the society as a whole wants to get to the bottom of.
Yeah, I appreciate that.
We're closing
That
our...
is- No, no, I know that, because that's where there's a commission of inquiry.
Yes.
It's a separate process. My question is somewhat different. We are now in this court, and is it for the first and second applicant to describe or to tell the applicants how they must conduct the case that they brought to this court?
No, except that the President and the government seek a stay, and all they have to do
No, but
is...
exactly, the President and government telling the applicants, you are not going to proceed with this case. Isn't that what is saying?
No, they asked my lady to stay the main application because they say not to stay it would not amount to real and substantial justice. It would
Why
be,
not?
Because what affidavits, I mean, what affidavits are the government going to file? I mean, the government could take a really, and the President, they could take a really, a sort of excessive procedural approach and say, well, you haven't laid out a case here. We don't know what the true facts are. In fact, your own affidavits say the true facts are to be determined. But, well, of course it could do that, but that's not the right approach for this government and the President to take. What they've got to do is they ultimately want, should it get to court, they want the court to do justice, real justice. I mean, they don't want the court to kind of have to deal with kind of technicality and a procedural, sort of procedural point, which is where we kind of argue, well, do you really make out your case here? And in fact, the problem that we have as government and the President is we can't file affidavits to this because we don't, I mean, what do you say? I mean, who are these people? So we need to investigate the allegations. We need to go and find the people whom you say were responsible for this. And my lady, we take it that they do, as I'll take my lady to the case law in a moment, well, not the case law, I'll take my lady to Rodriguez in a moment. It's true that when it comes to the allegations about interference in the Chikane case, it's true that there the government and the President can't deny that Mr. Pikoli and Mr. Ackerman set out sufficient information from which one could conclude there was interference in that case. It so happened that they ignored that interference and got convictions and sentences. But one can conclude from that there was an attempted interference. In Nkani Meng, the most one could say is that the family in the Timol case showed that they were told that it couldn't be investigated or prosecuted because there wasn't evidence. And yet, ultimately, evidence was found, presented to the inquiry, and at the inquest.
Yes.
And at the inquest, a finding could be made. So there they say, look, we were told that there isn't evidence. That delayed the inquest. And it is, I mean, that's the evidence. It is possible that they could argue that that delay
In
was...
those instances, although there had not been an inquiry, commission of inquiry, there were sufficient facts for the government to answer to.
Correct, my lady, because what happened ultimately was, at the inquest, the information was produced. And that's
But that's a different procedure from
Correct.
what we have here, the post-motion.
correct. It is different, my lady, but
No, I'm just
also
saying
the-
it is in an inquest,
Yeah.
one could call witnesses, which in a post-motion
well,
should not have.
you should not have to unless there are disputes and they're genuine and they're limited. But I mean, what would be the potentially there could be? I mean, if there were allegations of fact against certain individuals, apart from the Chikane case, which isn't relevant here because Chikane isn't, his family isn't here. He's not one of the applicants. So he doesn't complain, or his family doesn't complain that his case hasn't been prosecuted. These are families who, quite properly, and has this, the sympathy of the president and the government, quite properly, to whom one can be hugely sympathetic. They say, look, we don't yet have closure here, as they say. The prosecutions haven't happened. That is of concern and should be of concern to any government that cares about, one, its citizens, and two, its citizens who died in fighting for ultimately what we now see in the Constitution. So there's no question that obviously that must be, those facts we must find them, we must get them, we must locate them, we must expose them, shine a light on them, all those things. We've got to do that. But at the moment, you can't do that in the opposed application. Now, my lady asks, well, why don't you just go to court and say to the court, well, you haven't really made out a case. And on the basis of Bowman, D'Souza, Roldau, and all those cases that say you don't have to put up an affidavit if they haven't made out a proper factual case. Well, the President would prefer, and the government, to put up a proper affidavit where they say, well, this is what happened, because ultimately their interest is the truth. Their interest isn't to simply fight the families on procedural matters. I mean, that just, one can imagine how that would go down politically. I don't think it would go down very well, my lady, where the families say, what kind of government is this taking procedural points against us? And so the president is concerned that...
Well, if the families forces government's hand, then there's not much government can do.
Well, that is true, but government says there's a way out of this. There is a convenient way out of this. And the way out of this is to have the commission take evidence, make its findings, and all the problems that are highlighted in the papers, which is, well, that's down the road, it's another inquiry. We say, yes, all of those are true, but the point is, you will then have facts placed. Facts will come to light. And you can make of those facts what you like. You can, as the families, you can say to the commission, now you make findings, and these are the recommendations you make, including recommendations on whatever consequences should flow.
Well, it's not binding on the court.
That's true, but you could also go to court once you've been through that and you've got all the facts. And in fact, even before the commission has completed its work, you might decide, well, now you do want to go back, and you might have a case for successfully opposing a stay at that point, because you say, well, these are the facts in our cases. So forget about the commission's work, which goes way beyond the families. So it traverses all the cases, it traverses all people potentially with a complaint about a TRC case. These applicants, if they dig out information in that inquiry that involves them, well, I suppose they could then say, well, we're going to supplement our affidavits in the main application, and yes, you can come and apply for a stay, but we say you don't have to stay in this, because that can take its course. But we now do have facts. And we now want to ask the court to make a finding on these facts, and we seek whatever, whatever the relief is they seek, consequential, constitutional damages and so on. So my lady, the answer to my lady's question is, we submit that it doesn't do justice to simply to say to the President and the government, well, argue that they haven't made out a case, because the President and the government are concerned that that isn't the right way of going about getting to the truth. Then, my lady, just lastly, because I do think that my lady's gotten the drift of our argument, and I'm not going to
Belabor.
No, I'm not going to belabor or bore you, my lady, with my submissions, but I do just want to point this out. The Rodriguez case has become important, and it has become important because what's been said is that in the Rodriguez case, findings of interference were made. Now, let's find a bundle of authorities. Here they are. So, in the High Court, there was the full bench, Colopin J. It's a page, so my lady, it's the bundle of authorities.
017.
Yeah, 005-663.
Oh,
005-663.
Yes, thank you.
So what Colopin J, and I'm going to take you to the SCA judgment as well because it is in a similar vein. Colopin J found at paragraph 57 of the judgment is this: whilst it is manifestly clear that the political interference materially affected the ability of the NPA to properly deal with the TRC cases, in that the resources that were necessary to conduct proper investigations were not forthcoming. The NPA cannot, as it seeks to do, portray itself purely as a victim of the political machinations of the time. Whatever form the political interference took, and remember at this stage, even Colopin J doesn't know what it took. Whatever form it took, the NPA was enjoined in terms of its constitutional and legal responsibilities to act on behalf of society and protect the public interest. Colopin J then goes on to say, at paragraph 66, very much related to the above is the manner in which the NPA dealt with the disclosure of the acts of political interference in these proceedings. The main answering affidavit of the NPA was signed on 3 December 2019 and filed shortly thereafter. There was no mention made of the political interference that was brought to bear on the NPA. In other words, when they initially opposed Rodriguez's application for a permanent stay of his prosecution, they didn't say anything about political interference. The fourth respondent then filed an answering affidavit, wherein he set out in considerable detail the political interference. In our heads, we tell my lady what he actually sets out there. There are a series of conclusions. This included the affidavit deposed to by Advocate Piccoli in the Nkadi Ming matter, and that's the affidavit which is part of the main application, as well as the memorandum prepared by him in February 2007, expressing his grave misgivings about such interference and his reluctance to go along with it. It was only after this affidavit was filed that the NPA then revealed the existence of the political interference, and then also filed the affidavit of Advocate McAdam, which further detailed the extent of the interference. And my lady, even in its affidavit where it then says, look, we say there was interference. Now this is the affidavit by Victorious, and that would be Victorious' affidavit is 001-725. Here we go. It's paragraph 2.16. So it's 00. So it starts at 001-725, and starts at 2.16, where I'm not going to read all of it, but what Mr. Pretorius does here is he then deals with what preceded the delay in prosecutions. And he then says at 2.16.3, to the extent that the work of the amnesty task team contributed to a delay, the blame for that does not find a place to sit in front of the first offending's doorstep. So at 2.16.4, he says, at best, the government of the Republic could be criticized for not having entertained the thought of establishing another amnesty process similar to that of the TRC process. But that is as far as the criticism can go. There is absolutely no evidence placed before the court to suggest that the entertainment of such a thought was malicious and not at all in the best interest of justice. In other words, even in his affidavit where he concedes. And then my lady, my junior, says I must also refer you to 2.10, where he says, when regard is added to the nature of the crime, it should not be surprising that the government of the day may have taken steps to find a political solution to the political murders which were perpetrated. It is irrelevant as to what one calls these such steps. The fourth respondent calls them political interference with the NPA, and then he describes his position as follows. And then he then admits that, well, yes, insofar as he makes those conclusions, I admit those. So even in Pretorius' affidavit, we're not actually dealing with facts where this is the case. A member of the NPA says...
It's conclusions.
Yes, they're conclusions. But my lady, what you're really after is this. We had a file. And that file was virtually complete for the purposes of a prosecution. We put that file before whoever, doesn't matter, amnesty, interdisciplinary, ministerial team, doesn't matter, whatever. We put that file before them and we said, all we need is for an investigator to go out and find the following with us, because we have done our forensic investigation and there are these facts missing. And the NPA member says, at that point, X in the government said, you're not prosecuting this case. Put a stop to it, close the file, put it away. There's no such allegation, except in relation to Chicano. And that's what one expects. And of course, Pretorius is saying, well, yes, there were delays. We fought in the amnesty committee. We fought in the interdisciplinary committee. There were people who wanted us to take into account their recommendations before they prosecuted. Well, all of that took place. There were talks of another kind of amnesty, of pardons. All of that took place. But he says, well, you could call it political interference. It did delay the prosecutions. That's as far as he goes. So my lady, that's why the government says, and the president say, it is important for that commission of inquiry, because hopefully that is where people will be called who can do what I just suggested to my lady should be done, which is real hard facts about somebody somewhere in the state apparatus saying to a prosecutor, you cannot go ahead prosecuting in that file. We say put a stop to it. And if you don't, these will be the consequences. There's no such evidence. So, my lady, that's
How many families are before court?
Oh, my lady.
40?
They're quite a... Julie will tell you, I thought there were about 18, but there could be more. 22 families.
So, just for interest's sake, if in each of those families, it's 22 people, is that correct? 22
families.
So
they are...
one...
Yes.
So to take 22 files, would it be that difficult? And look at those files?
Well, no, I don't think so, but where? So obviously at the commission that will happen. So at the commission, the families, again, quite correctly will say, can we look at not just your file you have currently, but the history of our files, going all the way back. That's what we want to look at. And we want to, having investigated that and asked people questions about that, we then want to ask the commission or the fact finder, or the court ultimately, to make findings of fact against somebody in government, and therefore government, on the ground that he or she interfered with the prosecution in the case of a family member.
I'm just thinking the manner in which the other cases were resolved was because there was someone looked at a file, is that correct?
Yes, my lady. Someone looked at a file, and as Mr. McAdam will tell you, people didn't look at files for years. And that's the problem. Very little happened. It's a little bit like waiting for Godot. Nothing happened. In this case, for a very long time. So, just one last point I want to make. In the SCA case, in Rodriguez, what the SCA finds, so I've shown my lady what Applicant J finds. In the SCA case, the Dwaba J, who wrote the majority judgment, he finds what he finds at paragraph 26, and that is so this, my lady, was uploaded after all the authorities were uploaded. This was not part of the original bundle. I'm not sure what number it is in the authorities bundle. 26, Dwaba J says, it was during this 14-year period that the executive adopted a policy position conceded by the state parties. The TRC cases would not be prosecuted. Again, a very broad, sweeping conclusion. It is perplexing and inexplicable why such a stance was taken, both in the light of the work and report of the TRC, advocating a bold prosecutions policy, etc., etc. Then, he goes on to say, at paragraph 30, the ineluctable conclusion in all the circumstances is that political decisions were taken by the executive which may have affected the investigation and prosecution of TRC cases. That's as far as the Dwaba AJ, I beg your pardon, the SCA was prepared to take it. There were decisions that may have affected the investigation and prosecution. It didn't say that they did affect them. And then, Kachalia J.A., who wrote the minority judgments, he said this. Paragraph 52 of the judgment.
Yes, I do everything.
He says, apart from the delay and the consequent prejudice to the appellant that may have resulted therefrom, the other grounds relied on by the appellant to support the stay are either speculative or amenable to being ameliorated through less drastic remedies. The first is the accusation of political interference that resulted in the initial decision not to prosecute apartheid-era crimes, including the present case, and contributed to the delay. The NPA disclosed this interference, but insisted there was no trial-related prejudice. Allied to this ground is the contention that the prosecution is being pursued for an improper purpose, which overlaps with the case of political interference being made. The court rejected both contentions. Its conclusions cannot be faulted. And what happened? So what happened? In fact, what they're saying is, listen, in what Rodriguez said was he relied on political interference for his application to stay permanently the prosecution. And what Applicant J found and what the SCA says is, well, that's really neither here nor there. There may have been, but we're dealing here with a delay. And for the purposes of your delay, well, in fact, the NPA say, yes, there was a delay, but there was no trial prejudice. And the court, the SCA says, well, when it comes to a delay, that is really not, that's not a key component of our decision in deciding whether delay should result in permanent stay. It doesn't feature in our decision. It applied the rules, the common law rules, applicable to the stay of prosecutions. And it said, you don't comply with those. So my lady, even insofar as there is reliance on Rodriguez, and again we say that in Rodriguez what featured there was primarily what the applicants call, the families in this case call, direct interference. They refer to it in the affidavit under heading direct interference, and that is the interference related to the Chikane case. As we say, well, that's not going anywhere because that's been resolved. Unless there's anything else, my lady, those are submissions.
No, I will hear you in reply. Mr. Chaskelson. comfortable there, Mr. Chaskis?
Comfortable enough. Never comfortable in court. Milady, our learned friend has presented an argument that has a superficial common sense appeal. The basic proposition, if we understand it correctly, is that the President has appointed a commission of inquiry that will look at the same subject matter as this litigation. It will have tools to investigate the matters more deeply than this court. It will investigate thoroughly, and so our learned friend says common sense dictates that this court should not consider the applicant's application until the Commission has reported and made its recommendations. But with respect, my lady, on common sense, on closer inspection, this appeal to common sense breaks down. And it does so for three fundamental reasons. The first is a simple issue of fact. The applicants are seeking justice and recompense for crimes that were committed between 30 and 55 years ago. That's the period we're dealing with. The perpetrators of these crimes have either already died or are dying off at a rapid rate. If you committed a crime 55 years ago as an adult, by definition, you are at least 75 today. You're not going to be around much longer to face criminal prosecution. The applicants themselves are getting older and older. Many of their family members have already passed away, family members who were driving this process themselves. They don't have time to wait indefinitely for a commission of inquiry to report and for relief to be recommended and for the President to debate whether that relief should be implemented or not, and all sorts of steps to take place thereafter, which may or may not provide them with that to which they are entitled. And the one thing to which they are entitled is their day in court. And after decades of waiting, we're not talking about months or years, we're talking about decades. They are entitled to that day in court while they are still alive. That really should be the beginning and end of the stay. But the problem of delay is compounded by the nature of Commission of Inquiry proceedings that the respondents invoke as a reason for the stay. Recent South African history shows that commissions of this nature tend to drag on and on and on. It is an extraordinarily optimistic proposition to put forward the idea that this commission will be able to do a thorough job on its investigation and report in 4 months' time, which is all that it has left of the original 6 months. Even if it could, commissions are not institutions which can ever make final determinations. At best, they can make recommendations which the President may or may not choose to implement. This President has already changed his mind dramatically about whether to oppose the litigation or not. He first said he wasn't going to oppose, then he changed his mind. The administrations that preceded him are alleged to have been actively involved in the suppression of the investigations and prosecutions that the applicants complain about. The SCA has already found that there was political interference, or that there was a very real possibility of political interference.
Just a moment. As long as you do not interfere, I am trying to follow.
In this context, milady, the applicants are entitled to be a little skeptical as to how, when, and even whether the President would implement any recommendations that may emerge from this Commission of Inquiry in their interests. And even if the President were to adopt those recommendations, there's an entirely separate debate about whether it would be competent for the President simply to disburse public funds on the basis of a recommendation of a Commission of Inquiry. Our understanding of the legal position is that absent an order of court or an act of Parliament which would authorize payments of the sort that the applicants are seeking, The President can't just dip into the National Revenue Fund and start handing it out to people who he thinks are worthy beneficiaries.
So for that purpose, the applicants will need to come back to court.
Indeed, indeed. At the end of a commission to say, at best, well, now we've had the commission, there's been a recommendation of payment of constitutional damages. The President apparently accepts this. We now want you to order this as appropriate relief for violation of constitutional rights. But like a review application, this is not something that can be granted on an unopposed basis on where I stand up as counsel for the applicants and say the papers are in order, my lord and lady.
Now that would be more in the line of a settlement.
But even the settlement of this nature, a court would have to be satisfied was a legally competent settlement. And for that to happen, the court would have to investigate whether, in the light of the facts that are on the papers before it, constitutional damages was appropriate relief in this case.
Well, the recent SCA judgment seems to differ, that once parties have settled a matter, the court may not interfere and go behind that.
But, milady, that is the general principle. But I mean, it goes to the nature of the jurisdiction over appropriate relief for constitutional violation. Is that a matter that parties can privately settle between themselves? Is it a matter that a court has to apply its mind to?
It's not a normal civil. Yes.
We're not saying that this is a cut and dried case, and certainly if there was a settlement, we'd be trying to persuade the court. The settlement's in order, your ladyship can grant the settlement. But there is a debate there, and for present purposes, one has to assume that it is at least a possibility that just like a court cannot review and set aside an administrative act by agreement, it has to inquire into the grounds for the setting aside. The same principle would apply to the exercise of its remedial jurisdiction under Section 38 of the Constitution.
No, I hear you. It's a somewhat different remedy. It's not a civil matter with two private parties.
Well, it is private parties, but the remedy, but it's not a simple remedy in relation to a common law statutory right where the answer is foretold if the right is established. On any scenario, milady, the passage of time between the establishment of a commission and any ultimate action to address the applicant's needs is likely to be lengthy and one fraught with many uncertainties. And the applicants can't be expected to put their case on hold in the hope that the Commission will finalize its proceedings speedily. All of these uncertainties will be resolved. They will obtain what is due to them as a result of the state's fundamental betrayal of its constitutional obligation to prosecute the perpetrators of apartheid murders. And all of this will happen while they are still alive. And that is essentially what the President is asking in this case. There's one last submission that we make, my lady, which is that the request for a stay is constitutionally offensive, because it is a violation of the fundamental right of access to court. We strip away this veneer of common sense. What's actually taking place is the following. The President is a respondent in pending criminal proceedings over a justiciable dispute. He doesn't want to take a politically awkward decision. You just heard that. For political reasons, he doesn't want to choose where he stands in this dispute. So he doesn't want this dispute to go ahead and be resolved in court as quickly as possible. And why he doesn't want it is because it's politically awkward for him. So wearing his hat as president, not as respondent, he has created a body to advise him on the very issues which form the subject matter of the pending proceedings. And he's done that months after the proceedings were instituted. He's rejected attempts to mediate the dispute. This advisory body that he set up will have no power to bind him. Best it can make recommendations which he can reject or accept as he sees fit. Even if he accepts those recommendations, they'll have to be implemented. He can choose how they're going to be implemented. And in this context, he is asking the courts, your ladyship in particular, not to entertain the justiciable dispute that the applicants have brought before the court. He says, wait until my advisory body has told me how I should respond to this dispute. Then you can look at this justiciable dispute. But that's a fundamental violation of the applicant's constitutional right of access to court. That right is a right to have a justiciable dispute with the President determined by a court. And it's trite that justice delayed is justice denied. But that trite proposition has particular power in this case, because we're talking about applicants who include elderly family members of victims who were murdered between 35 and 55 years ago, and who don't know how much longer they have time on this earth.
So this is with the delay that
Indeed.
we've dealt with, yes.
So delay here acquires a particular power
Yes.
and importance. People have a right to have this case determined while they are still alive. And if the case is delayed indefinitely, and in the process some of the applicants pass away, then that's a fundamental denial of justice. And it's not your ordinary case where a delay of 6 months, a delay of a year is essentially neither here nor there. This is a particularly critical delay situation, and in due course I'll take your ladyship to the papers just to illustrate that proposition, because when one looks at the individual affidavits of the applicants, one sees how many of the family members have already passed away through old age or illnesses associated with age. How old the applicants themselves are, and how there is a very real risk that if this matter is not resolved soon, if the hearing does not take place at least on the ordinary basis, and one would hope on an accelerated basis, the people who want this justiciable dispute determined may not be here to see whatever the result is.
No, I do have that.
Now, if a private litigant came to court saying, let's put this litigation on hold, I want a year or so to give my advisors an opportunity to consider the subject matter of the dispute and to advise me so I know where I stand. Or you'd laugh that private litigant out of court. It's a preposterous suggestion coming from a private litigant. Now, the fact that it's the President who's advancing this proposition makes it worse, not better, because the President has constitutional obligations in relation to the fundamental right of access to the court. The President's constitutional duty is to promote, protect, and respect that right. A private litigant has no such obligation. The President's there to give effect to the right of the court.
The Commission of Inquiry part and parcel of executive functions. Must be if
the appointment of a Commission of Inquiry.
Yes, and the work that the Commission do, because the recommendations will be presented to the President.
Indeed, it is. But one has to separate the function of the Commission and the function of the Court.
No, but that is where I'm getting to.
Indeed.
Because the Court function totally separate, independent.
Indeed.
From the executive. So it's the three arms of government, and the judiciary should not interfere, and the executive should not interfere in the judicial process.
Absolutely. And I mean, there are fundamental differences between a court and a Commission of Inquiry. A court is there to decide disputes between parties. That is the primary judicial function. And a court, particularly in civil proceedings, does so in a matter which is not proactive. It looks at the evidence before it, and it decides on the basis of the evidence before it, not on the basis of any other evidence, whether rights have been established and what remedies should flow if they have been established. Then it makes orders if it has established that a right has been violated and there is an appropriate remedy. And once it makes an order, the party in whose favour that order is made has the ability to execute that order, to engage the machinery of the court to have it executed. A commission is a completely different animal altogether. First of all, it sits within the executive. It's there to advise the executive, the head of the executive. It can't determine any rights.
It does have the benefit of being able to call witnesses and for witnesses to be cross-examined. So it is a very useful tool, if I can call it that. But that's separate from the judicial system.
Indeed, it's completely separate from the judicial function. That only illustrates that. But your ladyship sitting in civil proceedings can't say, well, to get to the bottom of this, we really need to hear from X. So I'm going to subpoena X because I want to get to the truth. I don't want to decide the dispute on the evidence before me. I need to find the truth outside the evidence before me. So I'm going to subpoena this witness. I'm going to call for the production of those documents. That can't happen in the civil process. And what is happening in this stay application is two things are happening. First, the President is seeking to avoid having to make a politically awkward decision and is asking the court to spare him from making a politically awkward decision. That's a fundamental, it's fundamentally incompatible with the independence of the judiciary. The courts are not here to spare the President from making politically awkward decisions. That's really not the court's function. That is a violation of judicial independence to make that request. But in support of that request, the President is conflating the function of a court, which is to decide a dispute on the basis of the evidence that is brought before it, with the function of a commission, which is proactively to try to get to the bottom of everything, exercising inquisitorial powers, and attempting to get to the truth.
Well, having discussed these issues, maybe one should just go one step back. What is the test for a stay? It must be in the interest of justice.
But it must be in the interest of justice, but if one looks at the precedents, the ones...
Convenience?
No, it's more than convenience. A stay of proceedings is slightly different from a postponement, because a stay is linked to something else. It's a stay pending finalization of another process. And if one looks at the authorities, and we've done that in the heads, it starts at page 27 of the hard copy heads, it's 005 to 11. The test is the interest of justice. I'll come back to that test later. But the categories that have crystallized are fairly limited. There is one category where there are parallel civil and criminal proceedings. And certainly the old law was always, in those circumstances, you didn't want the criminal accused to be prejudiced by having to go on oath in the civil proceedings until the criminal proceedings had been finalized, so you would stay the civil proceedings pending finalization of the criminal proceedings. But these are both proceedings by courts of law. And even that principle seems to have been eroded substantially under the Constitution. There are a range of judgments which say the right to silence doesn't mean that you can choose when and how you want to litigate your civil proceedings when there's a pending criminal proceeding. But let's treat that as one specific category where stays were recognized. There was another category recognized historically that where a litigant had failed to satisfy a costs order in related proceedings, well then the proceedings that that litigant wanted to institute against the same party would be stayed pending finalization of the cost order. That's again a very specific category. Now outside those specific categories, when one looks at the case law in relation to stays, one sees there is a principle that if there are judicial or arbitration proceedings that will set up a res judicata or an issue estoppel on the matter before the court, and if it's more convenient for those proceedings to be determined first, then one would stay these proceedings pending finalization of those proceedings.
But res judicata, that's only in judicial
proceedings, indeed. When one gets out of the courts and one goes to administrative bodies that are part of the executive, there are cases where a statute that gives an organ of state the power to make certain determinations specifically vests the courts with a discretionary power to stay civil proceedings that may be determined by the administrative determination. And we've given some examples in paragraphs 43 and 40, footnotes 43 and 44 in paragraph 63.2. There are cases in copyright law that we've come across where there isn't a specific statutory power to stay, but the courts have nevertheless assumed that there is a power to stay pending a decision, or I call them intellectual property because they're not just copyright, pending a decision by the relevant functionary who will determine whether that intellectual property right exists, either by confirming a patent or granting a deviation from that, but do that administratively, and that determination will be a final binding determination in administrative terms. It will be binding, and because it will be binding, it will then determine the outcome of the parallel civil proceedings.
That makes sense.
And those examples we've addressed in paragraph 45.
That's somewhat different than what we have here, because it is in binding.
It absolutely, my lady, and that is the crucial issue. That we cannot find a single case where court proceedings have been stayed pending the finalization of other proceedings which will not be binding. The only purpose of staying court proceedings in this sort of context is if the subject matter of the litigation is going to be determined in another form, determined, not
Yes.
pronounced upon in a recommendation, but actually determined, then a court has a discretion to stay. And what's significant, my lady, is that in the cases that we've seen where the court doesn't have an express power to stay pending the parallel administrative process that will determine the issue, we have seen courts assume a power to stay. We haven't seen courts actually staying. They've assumed a power, they've investigated, and they have emphasized that that power if it exists, has to be exercised extremely sparingly, and on the facts of their individual cases, they haven't exercised it. But, so if one steps back and looks at the field of stays, one sees stays are clearly recognized where there are parallel legal proceedings or arbitral proceedings which will set up a res judicata that will determine the same issue.
Or would have a binding effect.
Which would have a binding effect. They are clearly recognized where a statute which sets up an administrative decision-making power that can determine the dispute before the court expressly vests the court with the power to stay if it's convenient to do so. And finally, there appears to be recognition that even if there isn't an express power conferred by statute, if the statutory determination will be dispositive, will determine
That's the inherent power that the court has to
Indeed.
its own procedures.
Indeed. But in that context, the courts have always emphasized that that is a power. The power of stay in those circumstances has to be exercised.
Yes.
And the footnotes in that regard, the leading and most recent case in that regard is cited at paragraph 45 of our heads. It's the Clipsal Australia case at paragraphs 18 and 19. It's an SCA judgment from 2010. What one sees nowhere is a power of stay being assumed, still less exercised, to allow a parallel process to take place within the executive, which will not determine the dispute, it will at best result in a recommendation to the executive responding.
Well, advice.
Advice.
What it boils down to.
Indeed. Who may or may not accept that finding. I'm going to go briefly to the papers just to emphasize the criticality of delay in this case. But before I do so, I just want to get past this red herring that has been raised in the papers, on the heads, and indeed in my learned friend's submissions, which is essentially an argument that, well, the applicants have made up no case. They're bound to lose. And your ladyship, with respect, put your ladyship's finger on that, the flaw in that argument, which is the applicants are dominus litis. If they, wrongly advised by myself and others, believe that they have a case that is arguable, but in fact they don't, well, then they will lose.
Yes.
That is how
It
it
could never
works.
be that a respondent say, stay the case, because applicant, you do not have a good enough case.
Indeed, indeed. I want to emphasize that we, this legal team and the applicants are confident in the merits of their case. But I don't want to take your ladyship
No,
to
no,
chapter and verse in this regard. It's frankly not the respondent's choice. The respondent thinks that we have no case, well then, let it stand up in court and say, you have no case. Dismiss, your application must be dismissed. That's how the resolution of justiciable disputes takes place. A party to a dispute can't say, well, actually, for political reasons, I don't want you to lose your case, so I'm saying don't run your case now, because then you will lose it, and I don't want to be
Seen.
I don't want to be seen to be winning this case. That's not the business. Well, a court should not give much credit to that sort of argument. Milady, if I can briefly go to the papers, I do want to spend some time here, even though the proposition is with respect self-evident, but I'd like to illustrate it with examples from the papers.
Mr. Chaskelson, I notice it's almost tea time, and if you are now moving to directing the court to facts, would this be a convenient
It
time?
would.
Thank you. Court adjourns until 3:30.
I think it's 10 minutes.
Sorry.
You know what? Do you need both? Do you need both? Yeah, I need both.
Yeah, I need
outlets.
to look at my camera. She's dying already.
Oh, the battery.
Betty, the Betty is dying.
Oh.
I can't even set up that light.
Yeah. Is it plug that side?
Thank you, Mr. Chancellor.
Lady, before I take your ladyship to the facts, I just want to conclude the section I was addressing with the ladyship on. And the President is saying, look, it's politically awkward for me to take a stand and take a position in this case right now. It wouldn't go down well politically for me to oppose. I'd like to wait for the Commission of Inquiry to investigate. Then government will know the facts, be able to take its position. But that begs a massive question, my lady, which is, government's had 25 years to investigate, and it hasn't done so. Why should the applicants be forced to delay now so that government can finally start investigating something it should have investigated 25 years ago? It goes even further. Your ladyship asked my learned friend, how many families are we talking about in this case? 22, said my learned friend. Well, leave aside the last 25 years. This application was launched 6 months ago. In 6 months, you can investigate 22 files if you have the desire to do so. Why hasn't government 6 months down the line been able to determine whether there was interference in any one of the 22 files relevant to the applicants?
So the documents should be easily available or not accessible.
Well, one doesn't know, but if government says, look, it's a very complicated issue because we've tried and we addressed these inquiries in relation to the first applicant in the case of the Craddock 4. In the case of the Craddock 4, one would imagine is self-evident. But assume government said, well, let's take the 15th applicant. We tried our best, but the documents seem to have disappeared. But there's nothing of that before your ladyship on the papers. What there seems to be before your ladyship on the papers is the complete absence of any effort to get to the bottom of why these victims, in respect of whom these 22 families seek redress, why their cases were never investigated and prosecuted. There is no evidence of that nature. And one has to assume that after 6 months, one could have at least come up with a position in respect of some of these applicants. There was interference, there wasn't. It's not like the members of the prosecution service who were tasked with doing these investigations are closing ranks and saying, I invoking my right to silence, I don't want to say anything about this for fear of incriminating myself. They're going on oath and saying, yes, this investigation was killed because of this, or there's no suggestion that any of these prosecutors, Ackerman, Pretorius, even Nuka, who was in charge of the prosecution service, had even been approached to find out. You say that there was interference. Well, was there any interference in this case? What was the interference? How did it? Nothing of that nature. There has been no attempt to investigate. And you can't choose not to investigate. First for 25 years, then for 6 months after an application is launched. And then say to the court, well, please, put this application on ice because it's politically awkward for us to take a position. And that political awkwardness is essentially self-created because we haven't bothered to investigate the facts ourselves, even in the 6 months since the application was launched. Milady, to get into the papers and the individual applicants' cases, and why delay?
I think the point cannot be disputed that these applicants have been waiting and they're getting older and so forth. That point in the stay application having been made, is it necessary to go to individual applicants at this stage?
Well, can I just give your ladyship a couple of examples? I mean, on the papers, your ladyship will see that a grandmother in whose home one of the murdered victims, grew up, is now 92 years old. Now, at 92, a stay of a year attracts a significance that it doesn't attract at 21. The reference there, Your Ladyship, is in respect of the 18th applicant. It's page 001-1109, paragraph 19.
Thank you.
But there are a succession of, if Your Ladyship reads the individual applicant's stories, almost without exception, they speak of parents, siblings who have pursued this cause and who have died. And the applicants, many of the applicants say, I am the sole surviving child of, or I am the mother of, my husband sought justice all his life, but he passed away in. That is a recurrent theme of this. I don't want to belabor the point, and I don't need to take Your Ladyship to a succession of references, but if Your Ladyship reads those individual affidavits of the individual applicants, one sees this story again and again and again. And that story just emphasizes how critical it is for the applicants to have their day in court as soon as possible, and for the stay, and for these proceedings not to be stayed indefinitely. Milady, I've already addressed Your Ladyship on the uncertainties relating to a commission of inquiry. It's a topic we address in the heads from page 201 onwards. Don't want to repeat my submissions in that regard. I've also addressed Your Ladyship on the unconstitutionality of this stay application. It's addressed in the heads from paragraph 55 of 005208. Just want to emphasize one submission in that regard, which is,
Because it is an important legal concept or legal
Indeed.
principle.
indeed, my lady, it's about the separation of powers. And we've already emphasized that the function of the court is to decide disputes. It's not to accommodate the political convenience of the head of state. That's offensive to the separation of powers and the independence of the judiciary. But if one goes to paragraph 16 of the founding affidavit in the stay application, one sees another element of judicial independence being brought into play. What the President's deponent says at paragraph 16 is the following, and we quoted it, paragraph 55 of the heads. Government and the President, supported by the rest of the respondents, submit that establishing the Commission has the following consequences. 16.1. Whether there was interference and collusion by whom and which investigations and prosecutions were interfered with should be decided by the Commission. 16.2. A conclusion of unlawful interference and collusion can only be properly drawn after a commission has heard and considered all the evidence. And this, with respect, is the executive telling the judiciary how it is to exercise the judicial function. You can only properly do your job as a court after the commission. That, with respect, is not something that the executive is allowed to do under our Constitution. It can't tell a court how or when to exercise its judicial function. So, while we submit that even on ordinary principles outside the context of constitutional issues, there's no case for a stay. There is a very, very important constitutional point here, which is this stay is being brought by the executive in an attempt to tell the judiciary how to exercise its judicial function so as to accommodate the political convenience of the executive. That is fundamentally offensive to the separation of powers, to the independence of the judiciary. Milady, that concludes our submissions. We would ask your ladyship to dismiss this application for this day and to do so with the costs of due diligence.
Yes, in reply.
Can we start by dispelling this notion that the reason that the President and the government want a stay is because they shy away from making awkward political decisions? That was not the submission when I addressed my lady. My lady will recall how that occurred. It occurred in this context. My lady asked, why don't the President and the government simply oppose the case on the founding affidavit as it stands? If the President and the government say there isn't a case made out there, there are no facts of interference and collusion. But what I said to my lady is primarily that is not in the interest of justice, because it is not in the interest of justice for the President and the government to say to families who do this in a notice of motion. One, they ask for a commission of inquiry. Well, actually, it's the other way around. One, they ask for a finding of unlawfulness and constitutional damages. Two, they ask for a commission of inquiry to establish the facts from which findings of unlawfulness are to be made, because they say categorically that that is what the commission must establish in the affidavit in the stay application. In the affidavit in the main application, and they repeat that in the stay. So my lady, what we say is, this is not a case. What our learned friends are doing is concocting separation of powers sort of disputes where they don't exist. There is no separation of powers dispute here. All the President and the government asked is, as they're entitled to do, where they are before the High Court, and they asked the High Court to exercise its inherent powers to regulate its own proceedings by staying the main application. And the reason, we come back to this, my lady, there's an inherent dilemma in the notice of motion and the founding affidavit. The applicants want a commission of inquiry to establish the facts, the true facts. And on the other hand, they also want to sue for unlawfulness and damages where there aren't true facts. I mean, that's the problem.
Well, that is sort of the view of your clients. It appears to me that the applicants and their legal team might have slightly different taking on there are no facts.
Well, then why is there, forgive me, my lady, sorry,
No, that was my point.
I'm sorry, I jumped the gun a little bit. Well, why is there a need for a commission? I mean, that's the point. We know why they're asking for a commission, because we don't know the true facts here. And it doesn't help to say, well, there's been this long delay. Why couldn't they have investigated in all this time? There hasn't been an investigation. Well, there have been. In fact, the families say that they don't want internal inquiries. They make that quite clear. They don't want internal inquiries. They object to them. And that's also why they call for an independent commission of inquiry, which, by the way, isn't advisory. The findings of the commission are effective in administrative law. They stand until set aside. So the idea that what the commission will do is advise the President isn't correct at all. If my lady sits, as my lady could, as the chair of a commission of inquiry, she's not advising the government. You might have been appointed by the President, but you're exercising your powers, your investigative, your adjudicative powers, in the context of a commission of inquiry. So my lady...
And that is akin then to administrative action.
Yeah, correct. And what the applicant's
Just a
court...
moment.
Sorry.
And the court will be bound by those.
Yes, but the findings, yes. Of course it will be bound by the findings. I mean, you can have them set aside on review, but until then, those findings bind everybody. Oh, I see. Oh, sorry. They bind the parties.
Yes. No, I thought that. Maybe
No, no.
that's a question mark.
No, they bind the
court
party.
is not bound. It might bind the parties. But the court is not bound by that.
Yes, but the decision stands until set aside. The findings, I beg your pardon, stand until set aside. So
So in that sense, the court is bound.
yes, the courts set aside administrative decisions, but until they set aside, well, everybody lives by them. I mean,
No. Oudekron.
yes. Correct. So my lady, the difficulty that the President and the government have is this. When you apply to court, and you seek both the Commission to establish the true facts, and you also want a court to find unlawfulness and damages on facts that are still to be determined, then the President and the government say, well, you can't do that. You've got to stay the one so that the other can run its course, because we all agree that it's got to run its course. They talk about delays. They say themselves, that's the families in the papers, they say that this is very different to the state capture inquiry. This is a limited inquiry and it should take, they say, no longer than 6 months. So they themselves say, look, we don't anticipate that there should be a delay. Now, do delays happen? Yes, they do.
It seems to me that if one has regard to the relief set out, the primary relief is the declaration of unlawfulness and then the constitutional damages. And then we only get the Commission in Press 6.
Correct.
So it seems to me that when this application was prepared and drafted, because one normally, what you want to achieve relief, one would set out Pre 1 and so forth.
But and I took my lady through that. If my lady, which she will, look at particularly the founding affidavit in the main application, and ask itself, my lady asks herself, why do they want a commission of inquiry? It's to establish the facts which are important for unlawfulness. That's the dilemma. So that's why we submit that my lady can exercise her inherent jurisdiction to stay. Now, what my lady was told was that the authorities are against us. We refer in one of the decisions referred is the Mapanga decision, and it's in the bundle of authorities. And in that decision, the court wasn't dealing there. A stay didn't happen in the context of either an arbitration or another court proceeding. And in fact, in Caesarstone, there, I mean, the court proceeding was in a magistrate's court in Israel, which I doubt binds the high courts here. But it was in a magistrate's court in Israel where the litigant said, well, stay this until that's decided. So my lady, the idea that the authorities say that my lady can only exercise her discretion in the limited context.
No, I do not think, because it can never be limited, otherwise there isn't a discretion.
Correct.
I think one is just looking for maybe examples of previous cases. I'm aware of the Mapanga matter, and that was also legal proceedings whether it would be binding, but I hear you.
Yes, and in Mapanga, they stayed the eviction application in the High Court until Remedial, by the way, the court did, and it said, well, you must go. And there, one of the litigants who was sought to be evicted had not gone to the rental tribunal. And the court said, I'm going to stay this until you do all of that. Hadn't even done that at the time. And did so Miramoto, and the Constitutional Court, as we understand it, held that was permissible. So the notion that the authorities are against my lady exercising her discretion in this context is not a sound one, because there are authorities that say that my lady can. Then my lady, what we did not do was we did not remind my lady that we also seek reinstatement of those.
Oh, I do not think that is, as I've read the papers, the applicants are not, the respondents are not opposed.
The reinstatement is not yours.
I thank you for pointing that out. I do not have a problem with granting the reinstatement relief.
I didn't ask for it, my lady. I got so excited about the argument.
It's very interesting argument.
Yes, it is a very interesting argument. So we understand. No, our learned friends have not opposed it. I just didn't. We never asked my lady to. We never reminded my lady that is one of the orders that we sought. Could I just check with my learned Julie if there's anything else? Those last questions.
Thank you.
Melania,
Just also there's one thing I never understood, and is that legally speaking, the findings of the commission, is that akin to administrative action?
that is why I stood up.
I was
It's
quite
not.
surprised.
And it's quite clear that it's not, Melania. And with respect, the leading passage of the Constitutional Court, the most recent decision of the Constitutional Court in this regard is cited at page 005-202 of our head's paragraph 40. It's what the Constitutional Court said in the State Capture Commission case, and quoting from what the Constitutional Court had said previously in the Safi Commission case. And there, in State Capture, in the passage reproduced in paragraph 40, the Constitutional Court said, notably in Safi 3, it was emphasized that, and we've underlined it in our heads, the findings and recommendations made by a commission established in terms of Section 84(2)(f) do not bind the President. The President is free to reject them in their entirety. And then it quoted from Safi. In the case of the appointment of commissions of inquiry, it's well established that the functions of a commission of inquiry are to determine facts and to advise the President to the making of
Advice, that's the word that I use. So,
Indeed, and the court emphasized the President is bound neither to accept the Commission's factual findings, nor is he or she bound to follow its recommendations.
so the courts are bound by that.
No.
Not the
Respect,
President.
no. The President
It's just suggesting.
nobody is bound. The only function of the Commission is to advise the President.
That's good, yes, that's the way I understood it always.
This is not, I think with respect, my learned friend is conflating principles relating to a decision of the public protector or a report of the public protector or another Chapter 9 institution with reports of the Commission of Inquiry. They are purely advisory, purely for the benefit of the President, who may choose to accept them or reject them at his will, both the findings of fact and the recommendations. And a court is completely unbound by them because a court is, it would be improper with respect for a court to have regard to evidence and findings in a collateral proceeding for the purposes of a decision in a matter where that court has to decide the issue on the basis of the evidence before it. But in relation to the status of a commission, the law is absolutely clear from the Constitutional Court in those two judgments cited in the paragraph. Purely advisory, not binding.
Thank you. Well, I've been thinking while I read the papers and listening to the submissions, it's very interesting. I mean, it's an interesting matter to me. And I think on a lighter note, all I want to say is I am glad I'm a judge and not the President. Judgment is reserved, court for
Yeah, I'm taking something. Yeah, but
Here or outside?
yes.
Yeah, because it's a background.
Because I come
They have, yes,
Yeah.
English is very good. So when are you coming to Australia?
I don't know. Not today.